5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth. Now I'm talking and you just cutting me off. Do you understand how this process works?
Oh, yes. Come on. This is not slavery. I'm not the one, I am not the one. I don't even have a license plate. What's your license plate?
First of all, I don't know who you think you're talking to. I don't have to answer you, and I don't answer to you. And I'm not going to...
This man is charged with felony retail fraud, which carries up to 5 years in prison and a $10,000 fine. But instead of focusing on the arraignment, he starts arguing with the judge about whether he even has to recognize her authority. Rather than dealing with the charge, he shifts the conversation to claims about the system not applying to him. On top of that, he can't decide if he wants an attorney or wants to handle the case himself.
25S00791. FY, people say the Michigan versus Timothy Dance.
Secretary on behalf of people.
Illinois, P87-146, Stephen in for the attorney of record, Dr. Donald, and I'm appearing on behalf of Mr. Dansley, who stands to my right. Mr. Dansley, can you please state your name for the record?
My name is Timothy Dansley, and I'm about to represent myself and I'll take counsel as an assistant. You know, so, I don't know who this being there. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer? You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork. I haven't received my discovery.
Well, that's what we got lawyers for, sir.
To the count machine to get to the lawyer very well to the county. So it's apparently hard. So I'm gonna need some type of system.
Okay, well, that's what we got for you. Okay.
I'm gonna represent myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
Well, first is I wanna go ahead on with the
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge,
I believe it's 5 years.
yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a brain to go with you.
Well, you can have but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. If nobody said you don't have a brain or anything, you just need to stop talking and listen.
And honestly, that tells you a lot about how this hearing is going to unfold. If you were facing 5 years behind bars, would you really tell the judge you don't answer to her? Let's break this down. He says he wants to represent himself, but at the same time, he wants a lawyer because he believes he isn't getting certain documents. That's exactly why representing yourself can be risky. You either rely on a trained professional, or you take full responsibility. You can't jump back and forth depending on the moment.
Charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So, preliminary examination is the probable cause hearing where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. So, you understand all that? Now, you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Danby today, and have not received any audiovisual discovery from my understanding.
I like to get if you don't mind. About the motion, you know what I'm saying, for the fact that I haven't been denied, you know what I'm saying, in the time denied, you know what I'm saying, in the prosecutorial misconduct, we see my discovery change, even though
Okay, that's a lot of talking. Where's the prosecutor? Where's the prosecutorial misconduct?
Well, I should have had my discovery, dog.
Sir.
Yeah.
Do you understand how this process works? Well, no, you shouldn't have had your discovery because this is the first hearing.
So, the first hearing, I don't prepare anything if I don't have any paper.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm just stand here and just like, oh, yes, come on, this is not slavery. I'm not the one, I am not the one. I don't care nothing about the United States. First of all,
apparently not. You must not care too much about anything, sir. Okay.
I don't even have a license plate. What's your license plate?
First of all, I don't know who you think you're talking to, but do you want to spend an extra 30 days No, you don't care. That's why you're here charged with something.
What is your life for?
I don't have to answer you, and I don't answer to you, and I'm not going to start now. You need to settle down. You need to settle down. Okay, take him out of here, please. That's okay. He's just having his.
The judge can clearly see he doesn't fully understand how court procedure works. Confidence is not the same as knowledge, especially in a courtroom. He's arguing about evidence at an arraignment like it's a TV show, but real court is mostly paperwork and process. Then he brings up slavery during a retail fraud case. That has nothing to do with the charge. It doesn't serve as a defense. It only distracts from the issue at hand. When the judge suggests he doesn't seem concerned about the seriousness of the case, that's a warning sign. Rejecting the legal system won't make the charge disappear. A courtroom isn't.
So we're going to adjourn this, and I'm going to waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right. So we'll give you, what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give like a couple weeks to do it.
Yes.
And he's going to want to see it. So you're probably going to need to have him take a laptop over there to the jail and take his license to practice law to it. Okay. All right. So the next probable cause conference on this charge is going to be.
All right. I just, to make a record as regards to that discovery, I do have paper discovery, which Sister Counsel has noted that has been tendered already. I do not have, does not agree that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on.
Court's available August 25th at 9:30.
August 25th at 9:30. And hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Gonick will be in trial in the William County Third Court. I make that paperwork for myself, but if you're wanting Mr. Gonick to be here.
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance, I would be more comfortable if Mr. Gonick just handled his own.
Well, you know what? You got to cut your teeth somehow. We've all had this.
Just don't
ask Miss Gracie. Okay. Ask Mr. Puda. We've all dealt with difficult clients.
We got Miss Gracie right. He's an expert in this.
I've had my share over the years when I was licensed to practice law. So, by his standards, I'm not licensed. Okay. Mm-hmm. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Gonick visit him and talk to him, and hopefully he'll be a little more settled down. Okay, that concludes that matter.
The place for broad debates about history. At this stage, the goal is simple. Answer the questions and move the case forward. Instead, he tries to turn the hearing into an argument about the entire system. And once someone decides the law doesn't apply to them, the outcome usually isn't surprising. The judge gives him several chances to settle down and cooperate. She even warns him that his behavior could lead to more time in custody. Still, he keeps talking over the process. There's a big difference between understanding your rights and misusing them. Facing up to 5 years is not the moment to test ideas picked up online. Would you ever represent yourself in a serious felony case? For most people, that would be a hard no. When the stakes are this high, having proper legal guidance matters. Thanks for watching. If you found this breakdown helpful, don't forget to like and subscribe.